Florida is now in session. The Honorable Rand Wallace, Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to, it almost seems weird to say this, an in-person session of the 5th District Court of Appeal. As I've been previously introduced, my name is Rand Wallace. I'll be here presiding over this case this morning. I also have joining me on this panel Judge Jay Cohen from Orange County and Judge Molly Nardella from Orange County as well. We have two cases on the docket. And we're going to go ahead and go forward with those two cases, and then after the second case, we want to invite the attorneys that are involved in the case for coffee just outside through the lobby of the courthouse. That's something that we haven't done in a long time, but we haven't had OAs in a long time either. So that's a tradition on our court from years past. So the first case is the Rodin Fuertes versus State of Florida. Mr. Pannell, I'm going to assume as the appellant that you want 5 minutes of rebuttal unless you tell me otherwise. And you may proceed when you're ready.
Good morning, may it please the court. My name is William Pannell, and I represent Carlos Rodin Fuertes, the appellant in this case, and I will take the 5 minutes for rebuttal, Your Honor.
Okay, you got it.
I'm going to focus my arguments on issues 1 and 2, but will certainly answer any question the court has on the other claims. Initially, it's our position that the trial court abused its discretion by refusing the defendant's request to instruct the jury that the state had to prove that the defendant intended to traffic in a specific amount of heroin and cocaine.
Let's talk about the nature of conspiracies in general. Do you agree that you can be in a conspiracy where you don't even know all the members of the conspiracy?
I do.
And that any acts that are taken in furtherance of the conspiracy, you are responsible and culpable for?
Sure, but you still have to have an agreement about, the case law is clear that there has to be an agreement when we have a conspiracy to traffic, an agreement or knowledge on part of the defendant about the specific amount.
Well, do you think that Way versus State is still a good law?
I'm sorry, which case?
Way versus State.
I'm not familiar with that case, Your Honor.
All right. It says knowledge of the weight's not an element in a conspiracy.
Okay.
Yeah.
So I would rely on the Hernandez case from the Florida Supreme Court 2010.
Counsel, Hernandez and Spivey, they're interesting cases, and you cited them for the proposition that there has to be evidence that the state introduces regarding knowledge of amount.
Sure.
It makes sense then that your argument that it has to be in the jury instructions, but as Judge Cohen just mentioned, there are cases, State versus Dominguez, State versus Austin, that seem to say otherwise. Are they incorrectly decided?
I believe so, and I think it's incompatible with Hernandez from the Florida
Hernandez
Supreme Court.
wasn't a conspiracy case.
I'm sorry?
Hernandez wasn't a conspiracy case, was it?
It was not, but if you look at...
Well, but that's a big distinction.
Well, if we look at footnote 6 in the Hernandez case, it says, as we noted in Brooks, the fact that Coco involved conspiracy rather than attempt does not render that case inapplicable here. Brooks, Coco, and the present case all concern the same issue, namely a defendant's intent to traffic in cocaine. So when you go back to the Hernandez case on page 5 of the opinion, if you're using the bottom page or page 759 of the opinion, it says when they're concluding that there's not sufficient evidence, it says instead it is sufficient that the defendant intended to be a party to a transaction involving at least 28 grams of cocaine. So he had to intend to be a party to a transaction, and then they talk about the Coco case from this court, which did involve a conspiracy, and they said that even though the cocaine that was recovered was less than 28 grams because the defendant had a conversation and intended to be involved in a transaction above 28 grams or more, that there was sufficient evidence. So it only makes logical sense that if you have to prove to support the conviction 28 grams or more, an agreement or knowledge, that the jury should be instructed as such. And Hernandez, specific from the Florida Supreme Court, and as far as I know, it has not been overruled, specifically says in both attempt and conspiracy cases that rule applies.
Well, Hernandez can't possibly stand for that proposition because it wasn't a conspiracy case. The holding of the case is not, in a conspiracy case, you have to have knowledge of the amount trafficked. That's not, that can't be because Hernandez was not a conspiracy case.
Okay, but the Hernandez court does say that the rule applies in both attempt and conspiracy cases.
And that's the nature of dicta.
Okay, well, I would respectfully disagree that that's dicta. I think, I understand that case did not, but they acknowledge and they approve this court's decision in Kokel that talks about conspiracy. And in that case, they talk about the agreement and the knowledge of the defendant being specific to support the conviction. So it would make sense under...
That's why I started with the general proposition. You have, the nature of a conspiracy is that you can have individuals who you don't even know are involved in it, and yet their acts and conversations, in this case wiretapping and testimony, you're culpable and you're responsible for the acts that were in furtherance of the conspiracy. Even though you didn't even know who the people were. You didn't know, necessarily what they were doing, but if you're involved in the general actions or plan of the conspiracy, the selling, traffic, of drugs, you're culpable. That's how conspiracies work.
I agree with that general proposition, Your Honor. I think it's different when you're talking about trafficking and the quantity of the drugs dictates the penalty.
It's conspiracy to traffic, not traffic.
Oh, I understand, but in the conspiracy scenario, the quantity of the drugs also dictates the penalty. And if you look at the Spivey case...
yeah, but Spivey was, so factually, inapplicable. Spivey had a bag of cocaine that was, just short of traffic amount, and then he had some cocaine on his person that appeared to be for personal use.
But again, Spivey talks about this court's decision in Kokel and about is there a specific agreement between the co-conspirator, the defendant, and another co-conspirator for an agreement to sell a trafficking amount?
But in Spivey, there was no evidence presented as to the amount. In this case, you had wiretaps where the co-conspirators were talking in fairly specific terms about selling kilos of cocaine and heroin. That wasn't the circumstance of the facts of Spivey.
But so in a conspiracy, Your Honor, the defendant has to have an intent to commit the specific offense that is committed. So the specific offense, that's what the standard instruction even says. The intent of Carlos Brian Fuertes was that the offense of trafficking in heroin would be committed. So he has to, and the offense charge is trafficking in 14 grams or more. So he has to have an intent to commit that offense. And the jury's never given that instruction, never told that he has to have an agreement or have to have knowledge. And I respectfully disagree with the court. I think Hernandez is a bright line rule and says that the Kokel decision applies in both attempt and conspiracy cases, and that intent is relevant in both circumstances. I don't see a way around that, and the state has not cited a case that contradicts Hernandez. So it's our position that the trial court abused its discretion because nothing in the instructions advises the jury that Mr. Fuertes had to intend to be involved in a transaction that involved a trafficking amount of heroin or a trafficking amount of cocaine.
Did the Hernandez case focus at all on the inadequacy of a standard jury instruction? a standardized jury instruction?
It did not, Your Honor. It talked about sufficiency of the evidence, but it's certainly a logical conclusion to say that if the evidence isn't sufficient because there wasn't knowledge, that the jury has to make a finding of knowledge or intent. I just think it's a fair, I mean, it's like 1 + 1 = 2. Like, if the courts are saying you have to prove knowledge to support the conviction, then the jury has to be told that you have to have knowledge or intent. Otherwise, it doesn't make any sense, because then the jury wasn't asked to make that finding. Additionally, it's our position that the court committed fundamental error by providing the jury with a principles instruction, because the defendant was only charged with conspiracy to traffic, not the substantive offense of trafficking cocaine or heroin.
Wouldn't the standard in that circumstance be whether a conviction could have been obtained despite the instruction?
I don't think so, Your Honor. I think this court's decision in
How would you distinguish?
I think what's happening here is if you have a reading of the instructions, a plain reading of the instructions, and this is this court's decision in Heathcock. It says, quote, "If a literal reading of an erroneous jury instruction lessens the state's burden of proving the crime charged, it constitutes fundamental error." So the Florida Supreme Court says
What about the Rodin opinion? I don't know if I'm pronouncing that right.
So the third DCA says, and I certainly will address Rodin, the third DCA says the problem with giving the principal instruction under these circumstances is that it allows the jury to find the defendant to be a member of a conspiracy if the jury concluded that he had done anything to aid or abet, and that's less evidence. So this...
Are you disagreeing with the basic fundamental rule that in order for us to find fundamental error, it's only if the verdict of guilt couldn't have been obtained without the assistance of the alleged error?
I agree that's the general rule. The more specific rule, when it has to do with jury instructions, is laid out by this court in the Heathcock case, 5 DCA 2017. Again, it says if a literal reading of an erroneous jury instruction lessens the state's burden of proof, it constitutes fundamental error. So it's our position that standard applies to jury instructions. As to the Rodin case, it's our position that case is factually distinguishable because in that case, the defendant was charged with both the conspiracy to traffic in cannabis and the substantive offense of trafficking in cannabis. And the court essentially says that the defendant invited the error because let me look at it. Because he didn't ask to limit the principal instruction in that case, and they relied on the law's case, their previous decision. The distinction is we don't have any substantive drug offenses. We only have conspiracy. So in Rodin and laws, you have both conspiracy and substantive offenses, so the principal instruction would apply to the substantive offense. So what should have happened is that the judge should tell the jury the principal instruction applies to the substantive offenses and not to the conspiracy offenses. But if you look at Rodin and laws, they both say that the lawyer invited the error by taking some action. Specifically in laws, there was principal language in the substantive offense instruction that the defense lawyer asked to strike. And then he also never asked for a limiting instruction. So what they said in laws and Rodin applied laws is that the trial lawyer caused this problem. Here that's not the case. The trial lawyer just acquiesced and said no objection. That's different. That's fundamentally different under the Florida Supreme Court's decision in the Allen case, where it says waiver or invited error precluding a defendant from arguing that an instruction constitutes fundamental error only occurs if the record indicates that counsel requested the instruction or knew that the instruction was incorrect and agreed to its use anyway. We don't have that here. We don't have, certainly defense counsel didn't request a principal instruction. He didn't request any instructions related to principles be modified like there was in laws. And there's certainly no evidence that he knew it was wrong. He just acquiesced to the instructions that were prepared. So
You know, the problem is, we're a court of correction of error, and the trial judge was really given no opportunity in this case to, correct that error. And I go back to whether a conviction could have been obtained regardless of the principal instruction. And I know you're focused more on the jury instruction, but I'm focused on the general proposition of law that this is how we analyze fundamental error.
And I understand, Your Honor, that that's the general proposition. The more specific proposition that has been applied by this court and other courts is in the jury instruction context. If the instruction plainly read reduces the state's burden of proof, and I don't think it could be argued that that's not what happened here. The
jury instruction here didn't eliminate a defense, right?
It did not. But in Heathcock, it didn't eliminate it. In Heathcock, it did not. I'm sorry. Go ahead.
That would be a significantly different scenario, would it not?
I don't know if it would, because in Heathcock, didn't eliminate a defense either. The Heathcock instruction was an attempt, and they said that reduced the burden of proof. Here we have a principle to conspiracy.
It'll be interesting to see the position you take in the next case that we're going to do this morning, then.
Again, the Heathcock case is the controlling case on jury instructions and fundamental error in this district. I understand there's a different general proposition for fundamental error, but the defendant doesn't get punished because, the state was there too, and they should have corrected the instruction. So I understand sometimes it's not fair to the trial judge to play gotcha, and I understand that's not the preference, but this court has said that the exception to that rule is where the burden of proof is reduced. Under the long line of cases of saying that principal instructions should not be given in conspiracy cases, it's clear that the state's burden of proof was reduced. So pursuant to Heathcock, it's fundamental error, and the trafficking convictions or the conspiracy to traffic convictions should be reversed. I'd reserve the rest of my time for rebuttal.
All right.
No alcohol in that, is there?
Well, it was served by this court, so
All right, okay.
I think it's on you guys.
All right, okay.
Volusia County's finest. So,
Thank you, Your Honor.
may proceed.
May it please the court, my name is Richard Pallas. I represent the state of Florida. And it's our position that for point one, that the special jury instruction, there was no abuse of discretion by the trial court in denying that. And for point two, that did not amount to fundamental error in the inclusion of the principal's instruction. To go off of this court's opinion in Heathcock.
So can we then dismiss the argument that you raised that it wasn't preserved?
Originally, I was reading through the record, Your Honor, because when that special jury...
A yes or no?
I don't want to give you yes and no, Your Honor, but originally that jury instruction requested was the knowingly regarding the trafficking portion of the conspiracy versus the conspiracy itself, trying to add new the illicit nature and new the amount of the trafficking amounts.
I'll tell you what, I'll help you out and we'll get you off of a losing argument and let you go to your other point.
Appreciated, Your Honor. So, in that case, moving on to whether the special jury instruction was preserved in this case. Just going to Spivey and Hernandez, those are cases that are solely dedicated to actually whether or not a conviction, there's sufficient evidence for those convictions. They're not going into the jury instruction for conspiracy with trafficking.
But counsel, I'm having a real trouble here, and I'm hoping you can help me out with the dissidence between requiring evidence to be entered regarding the specific amount, but not holding the state to whether or not they met that when you give a jury instruction. Why aren't those hand in hand?
Yes, Your Honor. Candidly, Your Honor, because the sufficiency of the evidence of this case wasn't at issue, I haven't thought as much about that particular jury instruction in our situation. But it's the fact that we have the subsequent instructions regarding knowledge afterwards, stating that lack of knowledge can be an affirmative defense and the like. that I think gets us away from that being an issue. Might not be the perfect answer coming from me, I do apologize. But really, with the special jury instruction, I think I'm more focused on, I believe, the fundamental error issue in the fact that Heathcock is a completely different animal altogether. The issue I have with Heathcock here is it's not as much as, I believe, negating the defense as it's negating the elements as what happened in Heathcock. I mean, in Heathcock, the attempt to commit sexual battery on a hapless person, the issue with that is that attempted was inserted in two of the elements. So they are stating the beginning of the attempt language and then saying to commit an attempted sexual battery. Here we don't have the defendant aided and abetted in the conspiracy logged into our elements. That instruction is tucked away in the back after the lesser included offenses are featured here.
Does the state have to prove in a conspiracy case that the defendant knew the amount of drugs that were going to be trafficked in?
I believe that can be inferred, Your Honor. I know a lot of our evidence in conspiracies we are allowed to rely on.
So they do have to prove it, is that your position?
Oh, I apologize, Your Honor. If I'm going back to the Atkins decision by the Florida Supreme Court in 2012, I know that they eliminated, with the adjustment of the statute, the knowledge requirement and moved it to an affirmative defense, which was then reflected in the in re instructions later on for, I believe, rules 25.9 to 25.13, Your Honor.
If they don't have to prove it, then why do they have to put evidence on of it?
Well, of course, we still need to show that a crime was being committed, because here in conspiracy, we're proving that they agreed with another to commit these crimes, and then we are proving on the other end that we intend that these crimes are committed. Of course, if there is no crime here, I believe in that case we couldn't have a conspiracy for no crime necessarily. And so, going off of that, it's the fact that we are agreeing that these amounts are going to be moved. Maybe not the specific amounts themselves, but I believe the case being able to... Yeah, I apologize, Your Honor.
Why don't you restate that, because if that made sense, it went over my head.
No, I promise you it was not making sense coming out.
Okay. Well, then we're in agreement.
Yes. I mean, it was, if I'm going back through that standard instruction, going into the trafficking amounts, after we begin it, we obviously start with the model penal code, knowingly possessed. That starts with the trafficking element. After it then goes into that we had a mixture containing heroin or mixture containing cocaine, and then moving into the amount, whether for heroin, the 14 grams, or in our case, it was the lesser included for the cocaine of 28 grams, not the 400 grams. We then get, after descriptions of certain terms, deliver, and mixture, we get into the knowledge section of that. And I believe that in there, us stating that we have to prove that they knew of the existence of the substance and intentionally exercise control over the substance, I believe that's enough for us here, that we don't need to necessarily get into that he knew the specific amounts, that he knew this was 28.7 or whatever the numbers specifically are.
You know, I'm beginning to doubt myself, because neither you or Mr. Pinnell are citing to that the Way decision, and so maybe I've misread that.
That's my apologies, Your Honor. I did not draft the brief in this case, but certainly that was authority that I should have located beforehand coming here.
Unless I've misinterpreted that case, I'll relook at it.
I mean, considering how that Wade case is, and at least cases like Spivey and...
Are you familiar with the Way case?
Off the top of my head, no, Your Honor.
All right, well, I'll reread it after an oral argument.
it's at least thinking of where the case law has gone in terms of conspiracy and trafficking cases. I mean, Spivey was, I believe, 1999, and the Hernandez case might have been 2010. Atkins, the case reflecting that the knowledge of illicit substance, that was decided afterwards in 2012, and then the amendments to the jury instructions were improved in 2013. But just to, again, return to Heathcock for the fundamental error analysis, again, that is, though the attempt language was thrown into the elements itself, and the state is, of course, of the opinion that the Rodin opinion is correct. And I know that it was stated earlier that Rodin was the trial counsel doing something that he shouldn't have done. I believe it was him not doing what he did. He did not object, and he did not ask for the limiting instruction. And here we have a substantive offense, we have the conspiracy offenses, we have no limiting instruction, and we have no objection. And so I believe...
You do acknowledge that giving the principal instruction was incorrect?
Your Honor, I admit that there should have been a limiting instruction as of the conspiracy charges, and that it would only have applied to the...
Why would you give it?
It's, of course, every of these, I believe, 13 co-defendants were listed in the unlawful use of a two-way communications device. In theory, one could hand the phone over to someone and say, can you order some drugs for me or something of the sort, which obviously here it wouldn't have been necessary because we had the defendant on certain phone calls.
I get a feeling you haven't participated in a whole lot of conspiracies.
I try to stay out of conspiracies as much as I can, Your Honor.
Okay.
But if this panel has no other questions, Your Honors, I ask that you affirm. Thank you.
Thank you. About 4.5 minutes left, Mr.
Thank you,
Pennell.
Judge. May it please the court. Judge Cohen, do you have to have the site of the way decision?
I don't have, I did not
Okay.
have it with me. I could run and get my iPad and give it to you, but
So the state relies on the Atkins decision in its brief and today at oral argument. My understanding of the Atkins decision is that it addressed the knowledge of the illicit nature of the substance, not the quantity of the substance. And it made the knowledge of the illicit nature of the substance, where a defendant was claiming, that wasn't cocaine, it was Epsom salt. They made that an affirmative defense, and the Atkins case said that was okay, and that was constitutional. It had nothing to do with drug quantity or knowledge of drug quantity, so I don't think Atkins has any application here today. The state, I think, has conceded that the principal instruction was inappropriate, at least related to the conspiracy charges. I don't want to, and that is certainly supported by the Ramirez case.
I wasn't sure that I got that concession, but...
He was close.
But
So, I mean, that's supported by a wealth of case law from the Florida Supreme Court and the DCAs. And without beating a dead horse here, I think when you read Heathcock, the language is from this court, further, if a literal reading of an erroneous jury instruction lessens the state's burden of proving that the defendant committed the crime charged, it constitutes fundamental error. And they cite Gilley from the second DCA. Here, a literal reading of the erroneous instructions in this case lessens the state burden of proof because it would permit the jury to convict it if it somehow believed that any of the appellant's acts, such as buying the victim and her friends several drinks, one of which they all thought may have been spiked, was more than simply thinking or talking about committing the crime of attempted sexual battery. So they found that the addition of the word attempted, so it was attempt to attempt. And they said that reduced the burden of proof, and despite the fact that there was no objection, it was fundamental error. Here, and so there was a reduction in the burden of proof. Here, all the cases say if you give a principal instruction in a conspiracy case, you're reducing the state's burden of proof. It's exactly analogous. And the fact that the state says, well, the principal instruction's later and it's not in the instruction, that doesn't matter. We have to assume the jury applied all the instructions, and followed the law, so they were given an instruction which allowed them to reach a conviction based on a lesser burden of proof. Pursuant to this court's decision in Heathcock, that's fundamental error. So we'd ask for reversal based on issues 1 and 2 and issues 3 and 4, also cumulatively issue 5, for the arguments made, based on the arguments made today and in the briefs. Thank you.
Thank you, counsel.